Production funding for Behind the Headlines is made possible in part by the WKNO Production Fund, the WKNO Endowment Fund, and by viewers like you. Thank you.
The state of juvenile justice, tonight on Behind the Headlines. I'm Eric Barnes, publisher of the Memphis Daily News. Thanks for joining us. I'm joined tonight by Josh Spickler, Executive Director, Just City. Thanks for being here again.
Thanks, Eric.
Keith Norman is pastor of First Baptist Church on Broad. Thank you for being here again. Bill Powell is former Juvenile Court Settlement Agreement Coordinator. We'll talk a little bit about what that means, but thank you for being here.
Thanks for the invitation.
And Bill Dries is Senior Reporter with the Memphis Daily News. This is in some ways a follow-up or a part two of a show on juvenile justice. We had Dan Michael, the judge from the Shelby County Juvenile Justice Center 2 weeks ago, which was a deep dive into how he works and how he views the role of the juvenile court. And you all have worked with him and worked with criminal justice, both juveniles and adults. And I'll start for each of you with a question I tried to pose to Dan Michael, which is, the juvenile court, and I'll start with you, Josh, the juvenile court, the Shelby County Juvenile Court, for a kid who ends up there should be what? What sort of place, what sort of outcome, what is its purpose?
I mean, it should be an opportunity for the child, and that is written into the law, as we've all discussed many times. It's not about punishment when you're a child, it's about rehabilitation, and it's about taking whatever it was that brought that child into contact with that court and using it as a chance for this community to keep that from happening again, to bring wholeness to the child and to a victim, if there is one, and to the community as a whole.
And is the Shelby County Juvenile Justice Center achieving that? Are they achieving? Because what you just said very much mirrors what Dan Michael said, and you've been a sometime critic of Judge Michael, but you mirrored what he said, I think, 2 weeks ago. Well,
the Department of Justice is here, as we're here to talk about, to help us address some issues that we're not we're not bringing wholeness, we're not bringing rehabilitation to our community. And the most important one and the most critical one is this idea that we're treating children differently based on the color of their skin. And that is the one area in this settlement agreement where we've made very little progress. And I think we can talk about all the details and all the nuances of this agreement and all the things that happen on the way to a resolution of a case in juvenile court. But what we have to start with, I think, and what has been too often dismissed by the court, is that we still continue, almost 5 years into this process, to treat children differently based on the color of their skin.
Reverend Norman, your thoughts on this, your thoughts on what should the Shelby County Juvenile Justice Center be to kids who do end up there, and where is it lacking or failing?
Well, I couldn't agree more with what Josh has already said. Where we're lacking and failing, I'd like to start there first, is that we're not learning from the things that are driving kids into these particular systems, and we fail them, because when a child is presented there, we automatically know that something has occurred or something has failed them in some way. And when we see the occurrence of this particular failure over and over again, it is incumbent upon us to fix that. Because whatever it is, wherever we're failing the kids, if it's within the school system, failure of activities, if it's a parental structure, we need to know that. And I think we have enough data now to know that. I think we see young people, young men and young women who present over and over again. And when they are in our system, we can learn from that. And when we learn from that, we should fix those systems. Now, I agree with Josh on another point. We have learned in some places, but young people who are, and I want to even broaden the conversation, brown skin, because it's not just African American kids alone now. We see this happening to our Hispanic children in some sense as well. And so we want to make sure that a system of fairness, and there are no dual systems where one kid gets this system of justice and another child gets another system. In particular, if a police officer is familiar or a sheriff is familiar with a particular kid in the outlying area, they're often talked to and taken home, or I know your parent, or I'm going to follow up with you at your school. But when inner city children, who by and large are children of color, are picked up, they're often taken straight to the center.
And Dan Michael walked through that. We walked through kind of a hypothetical scenario that he brought up of the middle class white kid in Germantown, say, or suburban area, and the African American child from the inner city, and talked through. And he admitted that there is different there is often different treatment. How much, I mean, there was so much that you just talked about that we could dive into, but one thing that strikes me, you highlight in the way you describe that, the fact that the Juvenile Justice Center, if we're talking about, the juvenile court, they don't bring the kids there. And Dan Michael talked about this, that they deal with who is brought to them. So how much of this is, on the shoulders of the Juvenile Justice Center to fix a problem out in the community, maybe a problem at home, a problem, as you said, in schools, or a problem with the police and how they treat the kids? Do we dump too much and put too much pressure and expect too much of juvenile court, given all those other factors?
Well, once the child is brought there, they should be treated in a just fashion. They should be given every opportunity. They should have all of the legal rights presented. There should be nothing that, quote unquote, railroads a kid into a plea of any type. So we should do all of the things that are there. Now, before they get there, there are some strategies that if this center produces data and says to the community, says to government structure, to our schools, to our churches, here is where we need your help. Here's where we need your partnership. This is where we can learn for preventative purposes in keeping the kids from actually getting to the center.
Okay. Bill Powell, I introduced you and I said we would go a little bit, your long and complex title. Tell me, your role at the Juvenile Justice Center was what? And you left in June of this year, is that correct?
That's correct. My role was kind of to serve as a liaison between the Justice Department, the monitors assigned to the case, and juvenile court in Shelby County. So essentially I would be involved in meetings with the court, looking at data, seeing what was going on relative to the memorandum of agreement, and communicate with the monitors to get their perceptions and try to reconcile those and talk about what progress had been made and what progress needed to be made. And I would communicate that through 2 reports a year and also through a number of meetings that were held throughout the year, both with monitors and with juvenile court staff and personnel.
The monitors, and we probably should back up, and maybe I get Bill to do this, Dries. In 2013, the court settlement that we're referencing, we probably should
2012.
2012, thank you.
Right.
Give us the backstory on that, and we'll go back to Bill Powell.
It was a settlement agreement that did not go to court. Essentially, the Justice Department investigated juvenile court for a number of years, came back with some findings on a number of problems that they saw in the court, went to the county and said, okay, we can do this one of 2 ways. We can file a lawsuit and probably then come to a settlement agreement, or we can just go to the settlement agreement right now and try to work things out. And the agreement was to go to a settlement agreement that would involve Justice Department oversight. And the way that settlement agreement, it's not just, oh, we've got an agreement and the Justice Department goes back to Washington and takes everybody's word for it. You have specific monitors who look at statistics, look at this in a detailed way, come here to visit, watch the court operate. And then you have a coordinator, which was Bill's position, over the entire agreement to make sure that this gets coordinated among all of the different parties in it.
Okay, thank you. And in the spring, Dan Michael, I think Mayor Luttrell, Shelby County Mayor Luttrell, asked Jeff Sessions, the new administration, the new Attorney General, to have the monitors go home, as it were. I mean, that enough had been met. There was no need to continue to be in this agreement. The Justice Department has not agreed to walk away yet, but that did not. Is it fair to say that did not sit well with you? The request to have the monitors removed.
Right. I did not agree that we had completed everything we had committed to do. The agreement that was signed in 2012 was an agreement between both parties. The county had input into formulating that agreement. It enumerated a number of things that needed to be done, should be done, and that the county agreed to. I had been working specifically on that since even before the agreement was signed, after the findings were issued. And I felt that we had made considerable progress, but we had not completed the job. We had not done what we committed to do. And from my position, from my standpoint, I had been meeting resistance throughout this from the court on a number of issues, and some of it was clarification, some of it wasn't just an outright opposition to it. But the work was hard, but progress was being made. And I was confident that we could complete the agreement and do it in the right way by honoring everything we had committed to do and making the changes that were necessary in this community. When the agreement was signed, we had all three elected officials basically standing up saying mission accomplished. I did not agree with that, and when the mayor signed it, I felt that my legs were taken out from under me, and essentially my position was irrelevant. That what I had been doing was trying to persuade the court, the sheriff, everyone involved that the agreement needed to be met. We needed to continue working on that. And I didn't see my role as being viable at a point where we sent a letter saying everything had been done and we had done enough. I did not agree with that. Went in, spoke to the mayor about that. I did not see the letter before it was sent. I saw a draft which looked very different. But when the actual letter was sent asking that the agreement be terminated, I could not agree with that, did not support it, and I went in and resigned.
All right, let me go to Bill Dries.
Bill, the draft that you saw, can you talk about how it was different? Was the draft letter something that you felt you could live with?
The draft letter didn't look anything like it. It was like two completely different documents. It was a difference between Macbeth and Romeo and Juliet in my mind. It didn't, and whether I could support it, I probably would not have gone in and resigned on that because it did not ask that the agreement be terminated. And that was kind of the kicker from my standpoint. Again, I felt that I'd been pushing against the tide with some success, but when all three elected officials felt that the work had been completed and publicly stated that, what am I pushing against? It's so.
At the press conference at the outset of this in 2012, Curtis Person Jr. was the juvenile court judge, and he said pretty prominently that he didn't agree with all of the findings, even though he was signing off on the agreement. Did that make your job more difficult? Is that the part of the tide that you were talking about?
It was part of it. I think that, and I had this discussion with Judge Person and many people through juvenile court throughout, a lot of them were offended at the findings and when the agreement was signed because they felt that they were being accused of making racially motivated decisions. I did not read it that way and never felt that way. I mean, the findings essentially said that there were disparate outcomes. It did not assign blame, it did not assign motivation, it did not assign intention to those actions, but that was simply the outcome. So what I had advocated for and pushed was, don't take that personally, let's use it as a self-examination to see what we're doing and why we are getting these type of outcomes when we're all working the best we can to ensure a fair justice system. So I thought we needed to do that examination. But a lot of people harbored ill will about that, and I think interpreted it as a accusation that they were making racially motivated decisions.
Have the monitors been fair in their approach to juvenile court?
Absolutely, they have been fair. And I think Judge Michael's comments on the last show were completely unfair to them. I've done this work before. I was involved in the agreement with the jail that we had. The monitors there were very difficult. They came here with the intention, we're going to evaluate you and we're going to nail you if you are not doing right. These monitors came in on an agreement, not a court action. We're under the impression that everybody wanted to achieve the same thing. They were very explicit in that they came in here to try to help. I think they have done that. I think they have gone out of their way not to be overly critical, and I think their findings have been spot on in every report they have done, And our failure to accept and listen to that has been a detriment in this action.
Let me say, too, that the show that you referenced with Judge Michael is online at WKNO.org or at MemphisDailyNews.com, so people can watch that. Josh, I want to turn back to you. One of the things that Judge Michael said last week is that, well, the requirements constantly shifted. That was one of the reasons that he was motivated to try to end this consent agreement. The other thing he talked about, and I get everybody's take on this, was, well, we live in a city that's 60, 70% African American. Of course, there are going to be more African American children picked up, brought in, and in the criminal justice system. That's just, they're apples and oranges in terms of comparing to other cities. So those 2 points, your thoughts?
Well, and to be fair, Bill can speak to both of those things much more clearly than I can, but to specifically to the, moving the goalposts or whatever phrase the judge used, again, Bill can talk about that. What we have, though, are monitors who have been reporting consistently for nearly 5 years now, up to, I think, 9 reports. And those findings have been consistent. And the one that hasn't changed, as I said earlier, is equal protection, is the way that we treat children, black children, children of color, white children, differently. And that hasn't changed. And what we constantly hear, and we've heard from Bill today, is this resistance to even the findings as they were stated in 2012. And we heard 2 weeks ago continued resistance to that, not discussing the data that these monitors are bringing to us, but talking about the monitors' motives for being monitors, how much money they've made, whether they're just mimicking what the Department of Justice attorneys are telling them. And that is a very consistent message that we get from the judge and from the court on this, and it's very, very discouraging.
Your take on that? Again, statistically, I'm not a statistician, but we've got a situation where 60, 70% of the population is African American, at least in Memphis. Wouldn't that just drive more African American kids into the jail? And this is a distraction from harder issues.
The larger question there is same offense, same process. So if the same offense occurs in another community and the same offense occurs with a child of color, is the process the same? Obviously, where you have more of anything, you're going to see more of that. If it's more women, it's going to be more women there. If it's going to be more men there. But in this case, what we're clearly talking about is the process was different. How the children were handled it was a completely different system. And so that's one of the major concerns. Let me go back to the monitors for a moment. I had an opportunity to meet with the monitors almost every time they came. They would call, they would arrange groups, we would have parents, and they would say, invite people, don't hand select them, randomly get them in. And so they were discovering the same thing over and over again. When we would have these forums, whether it would be at our church, at the Civil Rights Museum, or in other places, you would find groups of people who would, by and large, have the same complaint that may not have been in a previous group setting or have never ever met the monitors before. So the data was consistent, the findings were consistent.
Give me an example of the complaint. They would say X, Y, or Z happened.
Parents who constantly came to those forums would say, my child was told, if you go ahead and confess to this, or if you go ahead and admit that you've done this, then here's what would happen. In other words, there's a 16 or 17-year-old or 15-year-old in some cases who is being given advice by someone to say you need to plead to this or say that you did it and it will lessen the charge or do something different here. You can't do that with a child. You can't do that with an adult, but you definitely shouldn't do it with a child.
Okay, Bill, Dries.
Bill, you've heard the question here about the disproportionate outcomes. Yes. And minority contact here. Do we have a problem with that from where you sat as the coordinator?
There is no doubt we have a problem. Let me be clear. The court has done some good work as far as reducing the total number of children being held in detention, being petitioned into court, receiving diversion. Those kind of things, the court has done very good work. Where they have fallen short is exactly where Keith has pointed out. Children are not being treated the same. And again, I don't think that this is a let's put them on this track versus this track. It is not that overt, but the outcome for a black child versus a white child are consistently different at virtually every stage in the system. And Professor Lieber, who is the equal protection monitor who crunches all the numbers on this, has pointed out every time that similarly situated children are being treated differently based on race. So he's factoring out the offense, he's factoring out several other social factors, and the conclusion remains that children are consistently being treated differently. And we need to change that.
And then I'll go back to Bill, but just to clarify, outcomes would be
how much whether
time in jail?
A kid is detained versus being released, whether a child is petitioned into court rather than giving a non-judicial sanction, those type of things.
Okay, back to Bill Dries. We have about 5 minutes left.
If the settlement agreement had gone broader, had been beyond the three officials that we have, had involved, let's say, the District Attorney General's office, which makes a recommendation on whether or not to try a child as an adult, do you think we would have a better handle on disproportionate minority contact?
I don't know the answer to that. I'm not convinced that that's the solution to it, although there are roles that the DA could play, there are roles that the state could play, there are roles that the community can play. But I think what we're left with is the processes we have. There are problems administering those. And I think a lot of the solution to that is a self-examination of what we're doing. Are we detaining children for reasons that are not criminal justice reasons?
Right.
In other words, is a child held because his mother cannot come and pick them up?
Well, and that's an example that Dan Michael raised. He said, you know, he in his scenario, and I mean, I get it perfectly right, but of the middle-class white child from the suburbs whose parents come, he talked about a two-parent family versus a single mom who can't get off work or can't get there till later to pick up the child, or comes and says, look, this child is causing so much trouble in my house, I've got other children, I don't want to take this child back. I mean, he painted a very dark and grim picture. Your thoughts on that?
On part A of that, let me say that in some sense, we have always offered help for that. Our church has been one that has said, we'd like to volunteer with you and create a process so if this kid is having a troubled issue at school and it's not an offense that rises to the level of taking him to juvenile court, bring him to the church. And let's allow this to be a holding place, a homework center or something if we're talking about a minor offense.
And is that allowed under the law?
It is allowable because that if it's not an offense that rises to a criminal nature, if it's something where it's just disruption going on and we are a center whom has gone and met the criteria of the court and said, look, let us intervene here, that's exactly what we tried to do. Even if you pick that child up, if there's a drop-off center or other places, other cities and municipalities around the United States have taken opportunities to do this. We should look at some of the laws, particularly in Nashville, where the aim has been, how do we reduce taking so many people to jail and especially young people to juvenile court, traffic type or traffic related offenses and so forth. So we're criminalizing or we're raising certain things to a certain level and we're just pushing them into that system, then there's no way to get them out.
Josh, yeah, go ahead.
And I would say that it's important to say that we have done that through the course of this process of this settlement. We have driven those numbers down. And but I think it's very important to know, and that's what the court always says and said on this show 2 weeks ago, is that those numbers are down. And they are. There's no doubt about the fact that we are learning how to not take children accused of minor violations into the juvenile court system. We've done that. We've done a great job at that.
Is that at the police and sheriff level?
It's the whole community, but yes, there and the court. But what we still have is once they get to the juvenile court system, they're treated differently. And that is not a distraction, and that is the issue. The issue is not how many kids, it's how we treat them compared to each other. It's a comparison, not a total number.
Bill, you want to say something?
That's right. And I think a problem that we need to recognize is that a lot of those issues that are leading to disparity are because of our practices, policies, and procedures. We have not done a thorough enough job of analyzing those things that may lead a child to a certain outcome. That are not criminal justice related. And those things are not just with children being brought here, they are decisions made whether to petition, whether to give one sanction versus another. When this started, they did not have very many objective tools to guide those decisions. Thanks to the nudging by the Justice Department, some of those things have come about, but much more work needs to be done, and that work needs to target why are we getting disparate outcomes, not pretending they don't exist.
I mean, let me just ask a blunt question. Are we talking about simple prejudice? Are we talking about institutional racism? Is that what drives this?
I think that there may be some implicit bias that is related. Again, I have not encountered anyone at juvenile court throughout my time with this or any other time where someone was making a conscious, racially motivated decision. It is more a matter of neglect or a lack of getting the work done that is going to target those biases or those different outcomes.
Same question to you.
There are some assumptions that are made, I think, sometimes where people just don't have a cultural connection. I've been in situations where we assume that this kid doesn't have anyone who will pick him up, or his mom is not going to answer, or nobody cares. That's not our decision to make. Our decision is to make sure that we give this kid every opportunity as we give any other kid. And we're willing to go to that extent and not just push him or her into a system where they're going to be incarcerated and it's going to turn into something worse farther down the line.
All right, well, we are out of time. We will talk about these issues again. Thank you all for being here, and thank you for joining us. Join us again next week.
That we're not, we're not bringing wholeness, we're not bringing rehabilitation to our community. And the most important one and the most critical one is this idea that we're treating children differently based on the color of their skin. And that is the one area in this settlement agreement where we've made very little progress. And I think we can talk about all the details and all the nuances of this agreement and all the things that happen on the way to a resolution of a case in juvenile court. But what we have to start with, I think, and what has been too often dismissed by the court, is that we still continue, almost 5 years into this process, to treat children differently based on the color of their skin.
Reverend Norman, your thoughts on this? Your thoughts on what should the Shelby County Juvenile Justice Center be to kids who do end up there? And where is it lacking or failing? This Church on Broad, thank you for being here again. Bill Powell, former Juvenile Court Settlement Agreement Coordinator. We'll talk a little bit about what that means, but thank you for being here.
Thanks for the invitation.
And Bill Dries, a senior reporter with the Memphis Daily News. This is in some ways a follow-up or a part two of a show on juvenile justice. We had Dan Michael, the judge from the Shelby County Juvenile Justice Center 2 weeks ago, which was a deep dive into how he works and how he views the role of the juvenile court. And you all have worked with him and worked with criminal justice, both juveniles and adults. And I'll start for each of you with the question I tried to pose to Dan Michael, which is the juvenile court, and I'll start with you, Josh. The juvenile court, the Shelby County Juvenile Court, for a kid who ends up there should be what? What sort of place, what sort of outcome, what is its purpose?
I mean, it should be an opportunity for the child. And that is written into the law, as we've all discussed many times. It's not about punishment when you're a child. It's about rehabilitation, and it's about taking whatever it was that brought that child into contact with that court and using it as a chance for this community to keep that from happening again, to bring wholeness to the child and to a victim, if there is one, and to the community as a whole.
And is the Shelby County Juvenile Justice Center achieving that? Are they achieving? Because what you just said very much mirrors what Dan Michael said, and you've been a sometime critic of Judge Michael, but you mirrored what he said, I think, 2 weeks ago.
Well, the Department of Justice is here, as we're here to talk about, to help us address some issues.
Production funding for Behind the Headlines is made possible in part by the WKNO Production Fund, the WKNO Endowment Fund, and by viewers like you. Thank you.
The state of juvenile justice, tonight on Behind the Headlines. Eric Barnes, publisher of the Memphis Daily News. Thanks for joining us. I'm joined tonight by Josh Spickler, Executive Director, Just City. Thanks for being here again.
Thanks, Eric.
Keith Norman is pastor of First Baptist.
Well, I couldn't agree more with what Josh has already said. Where we're lacking and failing, I'd like to start there first, is that we're not learning from the things that are driving kids into these particular systems. And we fail them because when a child is presented there, we automatically know that something has occurred or something has failed them in some way. And when we see the occurrence of this particular failure over and over again, it is incumbent upon us to fix that. Because whatever it is, wherever we're failing the kids, if it's within the school system, failure of activities, if it's a parental structure, we need to know that. And I think we have enough data now to know that. I think we see young people, young men and young women who present over and over again. And when they are in our system, we can learn from that.